How are you?
I'm good.
Great.
How are things in New York?
Things are going swimmingly here in New York. Thank you for asking. All right, so we have a small group today, but that's fine. We're going to record this and send it out to everybody after the fact too.
Great.
So I just want to preface this by saying Mike Phillips is an attorney extraordinaire, but this conversation is really sort of a baseline conversation. If your state says otherwise, or has a great statute law or court case, or you know something that we don't know, please understand we're really just talking a little bit in general terminology here about competency and what it means to you. So I am not an attorney. I cannot give any sort of legal advice. Mike is an attorney, but he's not going to give you legal advice either, right? Boy Scout honor over there.
That is correct.
So everyone, this is Mike Phillips. He is my conference conspirator. He is a National Notary of the Year honoree from 2015. He's an attorney in California, and he deals on a day-to-day basis with all sorts of competency issues. So thank you so much for coming. I certainly appreciate you taking time out of your very busy schedule to come and chat with us a little bit.
Sure. So, hi, everybody. I'm Mike. I'm glad you're all here, and I hope you brought lots of questions. I have some things that I'll reference, but I think Marcy and I wanted to make this an interactive conversation. And so just a little bit of background on me as it would inform the conversation. So I am a notary. I've been a notary for about 20 years. I'm in California, so I'm a California notary. I'm also an attorney licensed in California, and that's about 20 years on that as well. And also, I do a lot of work. I'm kind of an attorney disguised as a social worker in that my day job is I work for a nonprofit and provide a lot of services for people who are in psychiatric hospitals, people who are in drug and alcohol facilities, individuals who are experiencing homelessness. I am getting people off the street and into housing, and we run some safe parking lots, people that sadly are new to homelessness and are living in their cars. This is a major issue in California as in other places, but California is really dealing with this on a big level. So the reason I mention that is because I have possibly a slightly unique or maybe different perspective on some of these things that some of you might be bringing to the table. And I want to start by saying that there's really no wrong answer on what we're going to talk about today. For the most part, we want to talk about, and I'd love to hear some examples and some questions from all of you, and I have some notes we can reference. Let's make this interactive, so jump in anytime. I'm an attorney, I talk a lot and I don't take a lot of breaths, but just interrupt and we'll be fine. But I think the idea here is that as a notary, when we meet with one of our clients and decide whether to proceed and notarize a document, what responsibility, if any, do we have to size up the capacity, the competency of our client, and in what settings? And then if we do decide that we have that responsibility, how would we do that? What exactly does that mean? And I did a presentation on this a few years ago with a gentleman named Michael Clausen, who's one of the top, if not the top, legal minds in the notary world, just a fantastic human being. And he and I differ a little bit on this, in that he strongly believes there is some duty to really get a sense of what the person who's signing, what their mental capacity is. And I'm a little bit more neutral on that, and I'll talk about why. I've found that, and welcome to the new people joining. I have found that notaries generally, in my experience, and I go to a lot of the conferences, present at a lot of the conferences, feel like there is almost this sort of heroic need to decide whether or not someone who's getting something notarized is really able to do so. And I find that it comes up a lot of times in the context of certain places like a skilled nursing facility or an assisted living, or the quote old folks home, to use the old colloquial language. And part of the work that I do has to do with individuals who are experiencing various levels of capacity generally, and there's a lot of legal processes in place that will step in and make a determination as to whether someone has the legal capacity to sign things and enter into contracts. And my take on that is there really isn't a reason why someone cannot sign a document unless a court has taken away that ability. And so there's various types of conservatorship. I'm sure you're familiar with that term, especially in all the context around some of the Britney Spears stuff, although there's multiple different types of legal conservatorships. And if you ever want a class on that, I can do that one too. But I think suffice it to say that someone has the ability to put their affairs in order until the court says they don't. And we can talk about absent the court stepping in, if someone seems like they are completely unaware of their surroundings and what's happening, then in that case, we probably would not want to notarize. But I also want to look at this from a stigma perspective and a equal protection angle, in that whatever we do for our clients as notaries, we need to be careful not to suddenly take on a whole different persona and list of questions and things when we go into a place that might be a skilled nursing facility or a place where people are receiving medical treatment, because one could argue that we are stigmatizing or bringing in some sort of bias into that environment and deciding that those people are less capable. And there's a lot of individuals in that setting that are still needing to notarize things. And to the extent that we decide that they can't, we've really put those individuals in a really tough spot, because they are depending on someone like us to be able to effectuate whatever transaction. And I always think, on the day that that's me, and I'm really sure that I want to sign off on a certain thing, and a well-meaning notary comes in and says, Mike doesn't really seem to me like he's passed the psychiatric exam I've designed for myself, I'm not going to let him notarize something. Then we've really put, in this case, me in a real bind, in that I may be on my way to losing capacity, but if I haven't lost it yet, then can you please just notarize this for me so my family doesn't come steal everything from me, for example. We know sometimes family members will want to be in an environment around someone that we might be concerned about, whether coercion or duress is involved, whether someone's placing undue influence on someone. But I also want to be careful there too, because I've heard some notaries say, if there's another person in the room, I'm going to insist that they leave the room. I get the sentiment behind that, but I think we need to be careful, in that it's my experience that a lot of my clients have a family member sometimes that they just really want to have there as a comfort, or as someone as a confidant. Remember, we're coming in as a stranger. And so if they are having someone there that is comforting to them, then we may want to be careful about removing that individual from the room in the guise of protecting them from maybe someone who is a bad influence, when maybe that person really, our client really wants the person to stay. So I'll back up for a second and say that in general, it is my belief that there is no duty on the notary to assess any sort of mental capacity or competency. And so I want us to be very careful about anything that looks like that's what we're trying to do. I think we all, a presentation I did a few years ago with Michael Clausen for the National Notary Association, I think we all sort of settled, in some of the guidance around this, settled on the word awareness. And I think awareness is a nice, safe word, because it doesn't have all the baggage that comes along with capacity and competency. But it suggests that it's nice for us to be paying attention as to whether someone has some awareness of what's going on during the transaction. But if we look at capacity and competency, those words are used so often interchangeably and back and forth that their meaning gets blurred one between the other word. Oftentimes capacity has a medical feel to it, where in the medical world, this person doesn't have the capacity to make a decision. Competency, many times in the legal world, they didn't have the ability to enter into a contract. Absent some sort of forensic analysis, or us being some level of a psychiatrist, which I would imagine most of us are not, it makes me a little bit nervous for us to assume some sort of responsibility that involves sussing out whether we think this person has the capacity. And then I would ask, if you are doing that, are you doing that to every single client that you meet? Or are you only doing that when you walk into certain environments where you think that there may be a greater likelihood that the person doesn't understand what's going on? I think I'll stop there. And then I've got some examples of certain states that do have some language that is a little closer to this. And I think Marcy called me up when New York, I believe it was sort of flirting with building in, correct me if I'm wrong, Marcy, it was flirting with building something into the notary law of New York that was going to suggest that New York notaries had to really kind of get in depth with a script as to sizing up someone's capacity or capability to sign something. And it sounds like that ultimately did not pass. Do I have that right, Marcy?
Yep, that is correct. But I want to step back and talk about competency review because I think for most of us, all of us probably, when we hear like determining competency or capacity, we always go to the elderly, right? Because we feel like that's the population, I think, for most of us. But competency and capacity also can be for individuals who may be intoxicated, right? Or, not even outside of the mental place, but the physical, right? Where maybe they are mentally aware, but they're unable to sign. So I think it's important to make sure to talk about this a little bit, that competency isn't always about just the elderly and their diagnosis, right? And I think Mike brings up a good point, is that someone having a diagnosis of some sort of mental illness or disorder doesn't necessarily make them automatically not competent to sign a document. But certainly we've all been at a closing or with someone where, it's a Friday and they're like, hey, it's happy hour, let's pull out a beer, or you walk into their home and, it smells of marijuana, right? And those are other situations, I think, that are important to make sure we include in this conversation. It's not always about the elderly, there are a whole bunch of different things. But when we talk about competence and capacity, was going into, like at the base level of this definition, what is it that really we're talking about here? Is it just the awareness that an individual has as to what they're signing? Are we responsible for making sure that they understand and know what it is that they're signing? Like, where is that responsibility? Because the lines tend to blur a little bit, right? Like, how many questions do we really want to ask them? How far do we get into it before we are not, like you said, we are not psychologists, we're not physicians, right? I'm not a social worker. I don't have the skill set to really drill down into that. And certainly that then causes maybe some unauthorized practice of law. Is, are we really in a position to determine those types of things?
Yeah, and I would say that the answer is that we're not equipped to do any of those things. And even the professionals that are able to go through multiple different diagnostic tests and mini mental status exams, for example, to determine it. So even if we were qualified, certainly we're not going to run somebody through some psychiatric mini mental status exam or some equivalent, just because it's somewhere between offensive and burdensome to do something like that. And again, we aren't qualified to do that. I think the best that I've seen is where there's a separation between something that sounds like an awareness of the transaction that's occurring. And I think that's the part where we can get involved. And then there's whether there's a capacity or competency to sign a document and an full understanding of that document. And I don't think we should be going anywhere near that. I think that in fairness, for good or for bad, probably a majority of our clients as notaries have not read the document, are not even sure what the document is called. I mean, I can't tell you how many times as I'm getting ready to put something in my journal, I'll say, so what is this again? And they'll say, well, and they'll look at the document and they'll study it, competency or no, capacity or no. So for me, I think that I always want to think, what's the easiest, fastest way to get a sense of what's going on without offending my client, and also without pretending to be a psychiatrist. And what I came up with, I think sort of mid-presentation with Michael Clausen when we did this, was to walk into the room, and whether there's family members or not, and even in a skilled nursing facility, person's elderly, whatever, and to say something like, hi, I'm the notary. How can I help you today? What is it I'm here to help you with today? And I think that is a really simple, comfortable question that the person should be able to answer. They should be able to say, well, I need to sign this thing about my lease, or it's something about it. And I think that if the person can answer that question, and if the family member starts to jump in and says, whoa, I'll tell you what, no, I'm sorry, thank you, I'm so glad you're here for your loved one. I really need to hear from her. What is it I can help you with today? And leave it open-ended. Don't ask a bunch of leading or yes or no questions. And just sort of say, what can I help you with today? How can I help? And if that person says, hi, I'm here to have you notarize this, and I wouldn't get too much into the details of the document, especially if you're doing a loan signing, for example. Those of you that are doing loan signing, we're talking, I've done thousands of those probably as well. You're talking 200 pages of stuff that we know they didn't read. And we know that they could not speak to all of that stuff. We know it. So it's kind of a be careful what you wish for if you're asking for questions around that. I think that if we ask, what is it that I can do for you today? How can I help? I get a sense that the answer that we get back will tell us exactly what we need to know. And someone may have some difficulty communicating, but still have the mental ability to notarize something. So I mean, I interact with clients all the time who have some struggle around communicating verbally, but still have the ability to understand what's going on. So whether it's passing notes or something to that effect. But I think that's about as far as I would go. And I have some examples of some of the states that do have some language that is close to suggesting that we have to pay attention to this concept at all. I look at the California notary language, and there's nothing that even comes close to an expectation of me deciding whether someone is aware, whether they're being coerced, whether they're under duress. There's absolutely no language that even mentions it at all. And so those of you that are that might read some language in some of there's a lot of books and ethical guides and things that are developed by the various notary organizations that they will add to what the law says. And it's good practice, but the lawyer in me says, well, if we scale it all the way back to what the law says, California does not impose a duty at all. And why does that matter? Because you might think, well, it doesn't impose a duty, but I care a lot. I want to do it. You want to be careful in the law about assuming a duty that is not given to us. Because if we take on a responsibility that does not belong to us, then if we do it wrong, or if we do it at all, there could be some liability if it somehow reflects negatively on our client. I don't think the risk of that is super high, but if for some reason someone's not able to get something notarized because we decided that we have a duty that we don't have, I think that's a risk that we run into too, and we want to be careful about that. So I especially with California law around the notary public, I get a little bit on the side of we don't have any duty to do that. And so be careful what we build in. And we want to protect, but remember protecting, I'm a big civil rights guy. We want to protect people, but if you're protecting someone from themselves and they still have the ability to sign, then we are, in theory, we're violating their rights. We're preventing them from doing something that they otherwise have a legal ability to do. Remember, we're there to check their ID, make sure they're physically present, make sure they've signed the document. And as for the larger legality of whatever that document represents, that's somebody else's business and somebody else's problem. And that doesn't mean we're not sympathetic to that or that we don't care what's going to happen next. But I think we really want to focus on what is our piece, what is our role. We have a function to come out and assist this person, have their document, have their signature verified. And that's really about it. So to Marcy's point, if someone is visibly intoxicated, or if we have the ability, I've been to signings where someone's like, hey, let's have a beer, let's bring out, and I'm saying, let's save that for the end or not at all. So to the extent that we have some say in it, for sure, we should discourage any sort of alcohol. And I mean, if someone's having, where do we draw the line? That's what makes me nervous. Someone's having a sip of wine while they're signing. Are we worried about that? I mean, does it have to be a crowded bar where everybody's drunk? So if we do assume these responsibilities, I think we want to be careful as to exactly when we think that threshold kicks in. The more extreme the situation, the more I think we can back away and feel comfortable about it. I would say definitely, especially if you're in a state that has a journal mandate, and if you're not, then get a journal anyway, because those are super important for us to capture our transactions. But I would say anytime you back away from a notarization, I would very much detail exactly why you did that. And I always say, pretend you're writing a little note to the jury just in case. Is there going to be a lawsuit because you refuse to notarize for somebody? Probably not. And I speak to, this is not the topic of this conversation, but I speak to concerns about perceived discrimination and other things. Always you want to have an objective reason in your journal as to why you said no. But unless it's pretty extreme, I'm going to still notarize for the person. And then you can make a note about anything that you have concerns about. And I think that I worry about us building in a process that is not something that is required by law, and also that it's not defined by law. In fact, some of the notes that I have here that speak to this, I went back and looked at the old presentation I did. It talks about how even places that are suggesting notaries do X, Y, and Z, even if it's not in the law, get really nervous about prescribing particular tests on how to determine capacity or competency, because they're afraid that they might only do those things and not do something else that might be a better way to handle a situation that's not mentioned in their suggestion. So I think some people say go with your gut, but obviously your gut is not going to be good enough if there is a challenge in a law. So you want to, if you go with your gut, that's fine, but you want to put something in your journal that says, here's what was objectively going on. To Marcy's point, I can smell the marijuana in the air. There's alcohol everywhere. This guy's slurring and drunk and doesn't know what he's doing. If you know, in the psychiatric world, we call it word salad, or someone is mute where they're literally not making any sense or have no clue what's going on. I'm not suggesting we go forward in those cases, but I'm also suggesting that we don't get super nosy all of a sudden and expect grandma to know every single aspect of the deed she's about to sign when we wouldn't ask those questions of somebody else. Any thoughts on any of that? Or Marcy, any?
I actually have two things I want to add.
Good.
So, you know, we hear a lot, and I'm sure everyone has, is that when you're walking into a nursing home or a hospital and there's family members there, that it's good to separate them, right? We don't want any sort of duress or prompting. And you're saying sort of the opposite. They may have comfort. And I think that we clearly see that. So I put out here in that this becomes one of those types of things where it becomes situational, right? Like we have to do a little bit of reading the situation. There are those individuals who I think we run into cases where we just see family members take over. Maybe it's because they're protective of their mom or dad, right? And they want them to sign. But what is a good way to handle those types of situations where you're not offending, but you're also not making them upset thinking that you're trying to coerce their family member into signing or not signing, right? It's a touchy situation, especially when we talk about end of life situations, right? Or significant diagnosis where their family member is really, ill. Those become places where we as notaries, I say, we get in trouble because we want to be helpers, right? That's where notaries run into problems, because you want to help, and sometimes that's not our place. So what's a good way to kind of offset that so it doesn't become a difficult situation, but still you're getting the information from that person who needs to sign?
Yeah, I think for me, and I import this from some of the work that I'm doing generally when I'm meeting. So a little more information on what I do. A lot of the work I do is in a psychiatric facility where someone is maybe detained against their will on a psychiatric detention, and it's my job to represent that person if they're saying, "Hey, I shouldn't be here, and I'm not." There's not reason for me to be here and I want to challenge it. Sometimes family members involved. And what I'll typically do is I'll say, I usually meet with my client in private, and I'd like to do that here, and then sort of wait a beat. And if my client, in this case, the person we're notarizing for, says, "Whoa, I want," I'll say, and then I'll look at the client, not the family member, and say, "Now, if you want her to stay, that's okay. I want to honor your wishes, but I need to hear from you that that's what you want." And then my expectation from those third parties, those family members, would be that they really keep their mouth shut during the actual notarization. I don't want to see that person sign here, mom, sign here, and just sign it. If that starts to happen, then I'm going to probably step in and say, "All right, I'm going to need to ask you to stop and refrain from those sorts of behaviors. If she wants you here for comfort, who am I to rip this daughter, this mother, this, whoever, loved one, husband away and kick them out of the room when that's their comfort?" Especially some people get in a place where they really, they really start to get nervous or anxious if you take that person away. So I think for me as the notary, you'll set the stage. You'll say, normally I would want to do this in private, get a sense of whether the client wants the person to stay. And if they do want to stay, I'll say, "Oh, that's fine. As long as she's consenting to this, that's fine. I'm going to ask you to," maybe I probably wouldn't say this unless they start getting involved. And then I would say, "I'm going to ask you to refrain from getting involved in the actual transaction. It's okay for you to stay here, but if you're going to start getting involved, this is my client. My client is the person who's getting something notarized. You're not. You can stay, but I need you to basically not get involved with the transaction. And if you do, I'm going to need to make a note of that in my journal, and I'm going to leave." And even sort of loosely float that, by noting it in your journal, whoever shows up next will review that, which of course is not the case. I also think too that depending on the laws of each state, we're not, as notaries, we are not mandated reporters, but we in some of us that are notaries have multiple jobs and multiple different roles and trainings. I don't think that it would be inappropriate if something seemed really egregious for us to make a call to whatever our jurisdiction's version of adult protective services is. I think that if something seems like someone's really trying to get away with something, because as many of you know, many of you have seen or suspected, a family member ends up in the hospital or something serious is happening, and all the family members will come out of the woodwork, and everybody wants to make sure mom signs the document so the stuff goes the way they want it to go. And sometimes they're well-meaning and sometimes they're not. And there's no way you could figure out, what is the best for, nor is it our responsibility. And we wouldn't want to get entangled in all that anyway. So I think, again, if our client is freely signing and is not being prompt or pushed, or I think it's one thing to just say, sign here, mom, if mom can't figure out where she's supposed to sign. But I would think anywhere beyond that, I would start to really push back on that person. I think removing somebody from the room can be, who am I to take somebody away from their loved one? But if they start acting up, then I'm going to say something.
Nope, that's great information. So Latanya has a question, and that bounces sort of off of what I was going to ask next. She wants to know, what about when in a medical facility, the signer has taken medication that impacts their mental capability? And my question was going to be, what if we're in a situation in, again, a hospital, a nursing home, a rehabilitation center, where there are obviously skilled professionals there, and we're really on the fence, right? The individual maybe is in oral, right? They can't speak, or they have a tough time signing, or we're just not entirely sure what the capability or the awareness is. Is it ever appropriate to ask their doctor, the nurse, right? Hey, we need this document signed. I'm just wondering if if the medication they take impacts, their mental capacity, or are they aware? Is that something that we can use, or is that something that we think would not be helpful or should not be asked in those situations?
Yeah, so I'll start from a place of what the rules say, and then I'll talk about what really happens in the world. You've probably experienced this yourself. So as many of you know, in a medical environment, there are many laws, federal laws and state laws around confidentiality. The one that everybody knows or has heard of before federally is HIPAA. It's the Health Insurance Portability. What is it? Health Insurance Privacy and Portability Act. That's the federal one, and HIPAA is the term that gets thrown around the most. Those doctors and those staff members should not talk to us, should not say anything to us, but they are sloppy, and they will if you ask them a lot of times. And I'm not encouraging you to ask because, again, they're not supposed to say anything. But I know from a lot of individuals that do work in hospitals and in psychiatric facilities and places like that, that's one of the tools they'll use. I will say that the providers should not be providing that information, even though they probably will. And two, the providers tend to be erring on the paternal side because they are of the belief that this person is in need of care, and that they will probably lean towards suggesting that the person does not have capacity. More so, they're not neutral in that dynamic. They're saying this person's in my care, this person's vulnerable. And if they're smart, they're going to err on the side of not weighing in on whether you should sign something, because then there's some potential liability for them. If they said, oh yeah, they're totally fine to do it, and you say, Dr. Johnson said it was fine, and Dr. Johnson later on is going to be like, I didn't say that. And so you may be stuck with that. I think also, even if someone and by the way, hello, Michelle, it's wonderful to see you. To Latanya's question, medication is tough because I understand where we would have that concern. And I see your hand up too. So I don't know if this is a part two to your question, but I want to acknowledge your hand, and I won't forget about you. I think that a huge percentage of the population is currently on some sort of medication, whether they'll admit to it or not. Just about everybody's walking around to some degree medicated, whether it's physical medicine or psychiatric or whatever. So I think the question becomes, when is that medication enough that capacity becomes an issue? And I think that certainly we are not going to be able to speak to that. And I know many doctors that really can't, to any absolute certainty, answer that question either. So for one, they shouldn't be telling us about the medication at all. But even if they do, if they say, well, they're taking Ativan and a little bit of Cyprexa, and they're a little bit of this, a little bit of that, I mean, at what point are we going to say, oh boy, yeah, for sure. I think for me, again, and frankly, a lot of the medication, if used appropriately, is designed to increase the person's ability to interact in their environment. So one could argue that the fact that they're on medication might make them in a better place to be able to understand what's going on, right? So it might not be a warning, it might be a solution to the problem. So I keep defaulting, even though I am an attorney, I keep defaulting to what is the simplest, easiest thing, which again, for me, keeps coming back to starting a conversation with the person and getting a sense if they seem to understand, why am I there? Who am I? What is my role? And I feel guilty because, again, I'm all about civil rights. I'm all about stigma and discrimination. I don't ask that question necessarily of people that are not in that environment. So I want us to be very thoughtful about treating people differently because of how they look, what their age is, what their skin color is, what their economic status is, what environment they're in. So if we've got this test that we suddenly whip out every time we go into a hospital that we never use in any other environment, just be careful with that. I mean, let's hold ourselves to some level of consistency that if I'm going to say, what am I here for today to the person in the psych hospital, then maybe I should say that to every single person that I interact with. Okay, Latan, you've been very patient. So thank you.
Thank you, Mike, for that information and
Sure.
the clarity on that. I wanted to add, because I used to work in the hospital, and so the local hospital, they have me on speed dial now. I went to a patient room, and I typically stay with the same questions, you know, when asked, just to make sure that, you know, they understand what they're signing, or at least they know somewhat of know what they're signing.
Yeah.
But anyway, walked in the patient room. His wife, estranged wife, wanted him to sign a POA, and he was okay with signing as long as certain changes were made. And he seemed shocked. I mean, he was shocked, you know, he knew today's date. He didn't give me any indication that, you know, he did not understand. So I stepped away. I said, well, you know, you discuss it with your wife, and I'm going to walk down the hall. So as I was walking down the hall, I ran across one of the physicians there. You know, they knew me, and he was like, what are you doing here? And I was like, I'm visiting patient, you know, blah, 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 and room, blah, blah, blah. He needed to sign a POA to give his wife permission to handle certain things. He was like, whoa, wait. He was like, he's not in any mental state to sign anything. And I was like, oh, okay. So after that experience, it just made me leery. And, you know, in most cases, I do, you know, go ahead and notarize a document, but at least I do ask, you know, do they know what they're signing? And, you know, just make sure that they are somewhat aware before I notarize.
And I think it's a really tough position to be in. And because I'm a bit of a smart ass, if I were in that interaction, I would push back and say, well, what do you mean they're not in any position to sign? What does that mean exactly? Is there some sort of, and this is to me just sort of technically going through the process, are they on some sort of a conservatorship? Are they on some sort of a probate or a conservatorship that would prevent them from signing? Are they legally prevented from signing anything? And sometimes the answer is yes, because you might not know that. And if that's the case, then that would likely be cleaned up later on, because somebody somewhere would say, that does know that, would say, hey, I get that they signed it, but they didn't have the legal authority to do so. In that case, if that legal authority has been taken away by somebody, then that decision then that's the end of it. But I wouldn't go asking that question in advance. I would have them tell me, or let someone else sort that out later on. To the extent that they say that he's not in any legal, has no legal ability to sign that, or no mental capacity to sign it, I would say, can you tell me a little bit more of that? By the way, they shouldn't have said that at all. But they're trying to be protective, probably. And I would say, if you're having a conversation already and they've already started it, I would probably say, that's interesting, because I just had a conversation with the guy, and I asked him what did he need me here for today? And he said he wanted to sign this document, and push back a little bit. I wouldn't want us to get in a real, knockdown, drag out fight about it. But I think that those environments, hospitals, psych hospitals, skilled nursing facilities, assisted living, those are traditionally very paternalistic environments, because for right or for wrong, they are of the mindset that people in their care are vulnerable, frail, in need of protection. And sometimes that's right, and sometimes it's not. So I guess for me, the disconnect would be, he seemed alert when I spoke to him. What am I missing? You know, what, help me understand.
And that's what I said, because when he told me, he was saying because of the mental capacity. So I was like, man, he was sharp. Like, you sure we got the same patient?
Yeah, and that's and I want to say too, if I can kind of go on a little bit of a tangent, that for me is maybe another way of looking at this. So in California, there's actually, in some states, there's actually, they added this little box at the top of our notarization forms that reminds the public that something that's been notarized by us does not give the document any sort of legal authority, doesn't make it legally valid, doesn't mean that someone now has to follow the, because there's all these, what you probably saw, oh my gosh, adorable. You probably have seen in the past, I've seen family members that'll get something notarized and then they'll have that seal and they'll go up and they'll say, this has been notarized. You have to follow this court order, you know, and it's like, that's not a court order. So there's language on there that reminds everybody that us having notarized something doesn't make it legally valid or any more legally significant than it was before. And I say that for a reason. Our role at its core is not to show up and say, we're going to make this legal and we're going to make this binding. It's really just to say, this signature on this piece of paper belongs to this person. Goodbye. That's our role, right? And so to some extent, because we're the only person there in the room, we feel, and you feel this when you're at a loan signing too, I imagine, this sense of I'm the only person here, and I think I'm responsible for a whole bunch of other stuff that's going to happen down the line, when we're really not. And so I think to the extent that something is outrageous, if your person, LaTanya, was like screaming, raving, and thought they were on another planet, then I would say, you know what, I think I'm out. But if they're alert and here's my driver's license and here's this and here's that and I'm signing, our role is to just say that signature belongs to that person for the most part. Or if they're swearing to something, if there's some sort of jurat or something that they're swearing, I swear this information is true and correct. If that part seemed to go pretty smoothly, that's our whole role. Our role is not to decide whether they had a mental capacity or whether that document's legally binding. Or frankly, sometimes when I teach classes, I teach notary classes as well. I'll say, frankly, what that document's about, it's none of my business. It is none of my business. And if they don't want to tell me a damn thing about it, they don't have to. What is my business is I need to see your ID. I need you to sign my journal. I need you to sign the document. And so if that part of it is going off the rails, I think we want to bail out. You know, you could document that the person as you were walking out, the hospital said, that person doesn't, but then I think if you documented that, you're only potentially causing problems for yourself, because then if for some reason that gets pulled and there's a trial or a lawsuit, then they're going to say, well, what were you thinking, LaTanya? These medical professionals said that the person didn't have capacity. I don't think we need to go there. I think sometimes keeping it simple is the best thing. My job is to show up, watch that person sign, have them show me their ID. And if at any point of any of those questions, they can't do it, or they start making no sense at all, then I think I'm going to bail out, because my part of it is so simple now that I think about it. I mean, not that notary work is not hard, it is, but the various aspects, show me your ID, sign here. Those are simple steps. So if the person can complete those simple steps without somebody forcing it, then I think that I don't have to add too much to that. And a simple conversation is frankly just good customer service. So whether you're trying to size up their mental capacity, you know, who doesn't want to be friendly? Who doesn't want to have a conversation? Who doesn't? And I think we probably do that with everybody. And what I like about that, as I'm formulating this as we go, is that is something that doesn't have to be, for the lack of a better word, discriminatory. I don't have to decide I'm only going to strike up a conversation with people in a psychiatric facility. I'm going to strike up a conversation with everybody. And if the conversation that I'm getting back doesn't make any sense, then I think maybe my argument would be, my part in this is very simple. And if they can't follow those simple steps, or there's something indicating that those simple steps were problematic, then that's probably a good way for me to bail out and a good time for me to bail out. I've seen people on 20 different medications that are clear as day. So, and really, you can ask that question and we, oh, medication, oh boy, but do we really know what that means? Do we really know what that medication means in that person? Do we know how much medication they're getting, how frequently they're getting it? So I wouldn't go there. I wouldn't go there, just because I think there's a certain inherent desire for us to be protective But keep in mind, if that person legitimately does have the ability to sign it and we walk away, who's to say they've got another option? They may not have another option. Who is going to help them? Maybe they call somebody else. Maybe they call another notary. Next notary shows up. Next notary does it for them. Next notary maybe doesn't even care. But I flinch a little when I see notaries that are so focused on protecting the client that for very little evidence they will bail out completely, and that makes me a little bit uncomfortable.
That was great information, Mike. Thank you. Does anyone have any questions for Mike or scenarios, anything they want to know before we hear about these other states that have something to say about this? We'd love to hear from you. Don't be shy. Hi, Jim.
How you doing, Marcy?
Good. How's it going?
I'm doing fine. I really appreciate this presentation and LaTanya's experience. I had one similar a while ago, maybe 8 or 9 months ago, and I just wanted to run that by Mike. I don't know that, just to hear your thoughts on it. So I had a call from someone who said his brother's in the hospital, needs to sign a power of attorney because he needs to, get on his bank account and write checks and that sort of thing, that his brother is near end of life.
Mm-hmm.
And so he said that he would have a few witnesses on hand in order to sign the power of attorney. So I met him at the hospital. One of the witnesses was his daughter, I believe, going from memory, which was fine. She was not mentioned in the power of attorney.
Right.
The second one didn't show up. So we went up anyway, and this was still back in a lot of COVID stuff going on. So, you have to check in, you have to have your mask on and all this stuff. And
Sure.
we went up, we talked to him. He was a nice gentleman. He obviously in maybe some pain. His color was ashen, I would say. I believe it was liver failure or something like that. So he probably had like 2 to 4 weeks, something
Sure.
like that. But he talked. He told me who he was. We talked a bit, and as his brother was talking, he even cracked a joke. So I felt really comfortable, like, he's with it. He understands what's going on, but we still needed a second witness. So I went out to the nurse's station and I asked, if one of the nurses would be willing to come in, and they quizzed me on, you're in room such and such. I said, yeah. Oh no, and they made it very clear to me. They felt that he was not in a capacity to do the signing.
Yeah.
Because just an hour before he was a little bit, I don't know, whatever, hallucinatory or whatever. But my experience in that room was that he was cogent.
Yeah.
He knew what he was doing. And as I'd studied up, so I knew that I could actually be the second witness in this case, since I wasn't notarizing my own signature. I was just being a witness. So we went forward with his daughter, and then I functioned as the second witness. But it really rattled me at the time. I was like, gee, I'm kind of going against what the hospital staff is actually recommending here by going through with this. They're the experts. I'm not the expert, when it comes to medical things. So it really, it set me back a little bit. I did go forward with it, and I did it, but it does my heart some good to hear what you're saying here, that maybe I wasn't so far off base in going through with this one.
Yeah, and I think that, and I like the way you broke it down. I like the way you mentioned that the witnesses were not mentioned in the document. We always want to make sure that's the case. And I know in a lot of situations, the notary is not supposed to be a witness. So to the extent that it was okay for you to be a witness, so I'll leave that on the table if you're saying that was the case. But I think I would break it down into 2 pieces. One, should you feel bad about that, or should you be concerned? I don't think so, because you say they're the experts, and I know what you mean by that. And this is no disrespect to care providers, because they are amazing and the work they do is essential. But these environments tend to be paternal, and they tend to be very overly protective. What I would say, the second piece of it in my mind, as I would parse it, is that woman, that person, whoever it was, has every right to not want to be a witness of that transaction based on their concerns.
Sure.
But I would not then refuse to notarize based on that. I would try to find somebody else. In this case, it could be you. If the interaction, I mean, again, there are so many different conditions. Someone can have sundowners where they're very alert during part of the day, and then during other parts of the day, they're not. And we don't want to get involved with trying to figure out when that is. You're having a conversation where, and also let's just add this. If whatever brought this person to the hospital, probably very stressful, end of life, very stressful, family members are there. Any one of us would be in some level of sort of, oh my gosh, that doesn't mean that I don't want to do the thing that I asked you to come in for and help me notarize. I could be having a terrible day and oh my gosh, this is a lot. I think that if every indicator is that this individual wants to move forward and that no one is forcing them to do it, I really think that assuming some level of responsibility for us is almost a burden that is too much for us to be asked to bear. We aren't qualified to suss out the family relationships in this very short transaction. We aren't qualified to suss out the psychiatric and medical and medication implications. I think that we're here to say, look, I'm a humble public servant. My job is to watch this person sign this, have them show me their ID, sign the book, maybe get a thumbprint if it's relevant, and then have a nice day, everyone. And I would put in, here's what I would put. I would put in my journal that if there's some concern about the setting, not that I have a concern about the setting, but that some objective third party might later. And of course, family members, we all know family members can start challenging stuff left and right after someone passes away or even before. I think I would document that the individual was in a medical hospital, met them on the medical floor, but I engaged in a conversation with them and they seemed to me to be very alert and participatory. And I didn't have any reason to believe that, I mean, you might not say you didn't have any reason to believe because then the nurse came running and saying, don't do it, don't do it. But I think that you can say as a notary, I had a conversation with the guy. He was making sense to me. And I you know, if someone else that's got better powers than me wants to check in on this after the fact, go ahead. And there are mechanisms in place. There are ways to challenge that. There are ways to challenge the document, to challenge the capacity. And those things would all be challenged after the fact in a courtroom, forensically, maybe after the person's no longer alive. There's mechanisms for that. So all of the burden, all of the weight is not on us if we got it wrong. So I think that's part of it too. There's that pressure, that human pressure on, I don't want to screw this up and I'm the only one here. Well, there are remedies. There are other things that can take care of it. And frankly, by people who are better qualified to do that than us. So for me, if we're vibing, for lack of a better word, then I'm in. I'm going to sign it. And I'm not talking about whether I get paid or not, because honestly, I don't think any one of us is going to say, you know, I want to get paid the amount that we're going to get paid, and I'm going to put this person's future at risk. Or none of us would. None of that would be part of an association like this would be making that trade-off. So let's just take that off the table right now. I think that as long as we get the sense that we can communicate and the person seems alert, I like awareness, because competency and capacity are legal terms of art and clinical terms of art that have so much baggage attached to them. Awareness is like, we talked, guy made a joke. He was cracking. I mean, at the end of life, guy's making a joke. He's doing a whole lot better than most of us on a bad day, right? So I think I would go forward on that one.
Great, thank you.
Thanks, Jim. And Tammy has a question, and I'm not entirely sure if I understand the situation entirely. So I'm going to have you unmute, but I do want to pull out part of it real quick because Mike and I have had conversations about this all the time, and he touched on it just a little bit. Mike will tell you this too. If I don't put it on a Post-it note or it doesn't go on my calendar, I don't remember. It's not getting done, right? There are some people in general who just are not good. And as I've gotten older, you know, the big 5-0, I'm not as good with that kind of stuff anymore. But we talk all the time about when your people are in the hospitals or nursing homes. Like we want to go in there, want to ask them questions, right? Who's the president? Where do you live? What day is it? And Mike and I say to him, I'm a notary and I don't ever know what day it is, right? I have to look at my phone or the calculator. And that's why in those skilled facilities, they put that calendar right on the wall across from you in your head, because time is not cohesive when you're in there, right? I mean, you go on a Tuesday and before you know it, it's Friday and you have no knowledge of that. So those kinds of questions, and Mike, you tell me what you think about that. I don't think that they're good questions asking someone in those situations because they're just not conducive as to whether they're aware, right, or competent. That's a hard thing for some people. Would you agree with that, or do you think that I'm totally off base?
Again, we get so paternal. As humans, we judge out of a protective nature. And then when we're on the other side of it, it's like, wait a second. I've been in a hospital for a week several times. I don't know what day it is. I don't need to know what day it is. It doesn't matter. You lose all track of time because it doesn't matter. Recently, mid-pandemic, I bought this clock. It's got the date and the day and the time. It's got everything on it. And I ordered it off Amazon, and it said arrives in discreet packaging. And I was like, what is this? But so your loved one won't know that you're buying. I'm like, what are you talking about? And then I talked to some of my friends in the hospital. Yeah, that's a memory care clock for people in the memory care unit. I'm like, oh, okay, well, I'm sorry, but it's in a pandemic, and I went through the whole damn thing, and I don't even know what month it is. So I don't think that we can get too judgy around the month or the date. Also, you show me a relationship, and I'm going to show you one party that's a little more domineering than the other one. So I think that asking what the date is doesn't bother me so much. I think that
Like you're breaking up just a little on us here. Oh, let me see. Yeah, I got everybody muted except for me. It doesn't seem to help. Let's see.
Okay.
One more time. I can hear you now. Oh, no.
Okay, good. I hear you. You're muted.
I am muted. I think you're okay. Go ahead and we'll let you know if it's not.
The question that makes me a little bit nervous is how should I proceed? How should I proceed in this fact pattern, assuming this fact pattern was designed with intentionality by Tammy? How should I proceed makes me a little more uncomfortable. I don't know what the date is. I mean, I signed a bunch of documents outside my office 5 minutes before this class, and I had no clue what the date was. I asked my team, what's the date? And they all yelled it out. I don't know. I see, I knew what I was signing. And so I think that if someone was saying something to that effect, I might say, sir, how are you feeling right now? Right? What's your comfort level with this? Do you have any questions, any thoughts? Maybe we should take a pause just for a minute, just take a beat, just to maybe give a little space around it and see where that person's at. A lot of documents, the more important they are, the more stressful they are. You do loan signing, the client, what do they say? By about page 10, after slowly looking at each page, they say, I'm signing my life away, and then they just speed up, right? These are stressful transactions depending on what they're signing. So I don't think we should assume that people should be happy-go-lucky and racing through whatever document. If they want to pause, take a breath, I think we give them that space. If we have concerns about, in this case, the spouse, hey, sir, or hey, ma'am, can I just ask you a favor? Can we have a little space? I need a little bit of space here. I feel like I need to be sure that this person is doing this because they want to. And can you give a little space? I see couples. I used to work retail many years ago, and I'd see couples just bickering left and right in the checkout line all the time, and it was a normal thing. So I would say that only when it seems like that behavior is causing our client, the signer, to potentially do something that is not of their free will. And then I would say, whatever I need to do to give a space. Hey, partner, partner, not partner, accounting partner, but your partner in life. Maybe can you give a little space? Can you give a minute? Maybe we can, and maybe in that case, you might say, can I have a moment with this person in private? And then see how they react and see if they freak out. And then what I would do is say to the person, my client, hey, is it okay if she's here? I just want to check and make sure you're comfortable. Is it okay if she's here? I just want to make sure you're comfortable with that. If so, we'll bring them right back in. You get the sense that maybe there's some discomfort here. Am I wrong? And then if they say, no, I want her here, I want him here. Okay, all right. Maybe that's their dynamic. Maybe they're just, that's the way they do things. So the only part that's going to make me nervous is if it seems like he literally is at a point where he doesn't know what he's doing or why he's doing it, or where he's having second thoughts, where he's stuck. Not knowing the date doesn't mean anything to me. I'm not worried about that. But if he's like, why am I signing this mid-document, then I'm concerned about that. I see Latanya's got her hand up. Marcy's coming off mute.
because you're breaking up just a little teeny tiny bit. So you want to like go on mute and come back, or turn off your video and come back. Sometimes that works, that whole on and off thing.
Or you might want to check, there's a arrow next to the stop video button, and make sure, I'm sorry, next to the mute button, to see what your microphone is using as the resource, and you might have to switch it.
To check that.
Sometimes that helps.
So if I'm still breaking up, I'll go on video.
Okay. I know now, how do you handle, like with the jurat, you have to put them under oath. So they have to, with the verbiage that we usually use, you know, they're swearing that the information that they provided is true and correct within the document. And I know that we're not supposed to care what's in the document, because usually I don't. But as far as the, you know, awareness and competency, how does that play a role when you have to put that person under oath?
It's the same thing. I mean, I think so. Michael Clausen was here, and I don't speak for him, and I hope he would feel like I got this right.
You're still breaking up a little, Mike. Do you want to try that?
Let me try going off.
And Michael Clausen can't come here because he doesn't know how to do Zoom. I tried. Don't tell him that I told you all that.
Well, am I a little clearer with the video?
No.
No, I'm saying, let me jump out and jump back in. How about that?
Okay.
Leave, and then you guys talk amongst yourselves.
We'll talk amongst ourselves.
Okay.
Tammy, did that answer your question? Because we'll bring you back if that didn't. Are you there, Tammy?
Hi, I'm
Hi.
sorry. Hi, sorry. So yeah, basically he did. It was a signing where I'm not sure I should have proceeded, honestly, because I've had a couple of signings now where the spouse, you will tell them what the date is, and then they'll like, I'm sorry, what is the date? What am I supposed to be writing? And so, you know, that cognitive, I'm just not sure if I should have proceeded with a couple of signings like that.
What I missed? Anything good?
Oh, you're in a good state. I just had Tammy jump back on to see if we answered her question. And so Tammy, do you want to repeat what you just told us?
Yeah,
Mike says?
Yeah, absolutely. I said there were a couple of signings that I've completed where one of the spouses was domineering, one wasn't. But just cognitively, you know, as we're signing every page, and there's dates that have to be written on every page, you know, we would write the date out for the person in front of them, put it on a huge sign. We would tell them, and probably 2-3 times on that very same paper, they would ask again, what's the date? What's the date? So, you know, when I look back on that in hindsight,
I think we lost Tammy. Did we lose Tammy? Marcy, you're on mute.
I know, I'm on mute. Tammy, are you there? Did we lose her?
I think we got, let's hope she rejoins. Can you, am I okay this?
Yeah, you are good. So do you want to go back to LaTanya and her question?
And then we'll wait for Tammy to join again.
Yeah.
So, LaTanya, remind me what we were talking. See, look, where's my capacity, right? Where's my competency?
I'm not notarizing for you.
Right? I mean, really, and that's me keeping it real, because like, we're all struggling right now, right? If you're not struggling, I'm worried about you, because something's going on.
What kind of medication are you on if you're not struggling?
Yeah, exactly. I'm like, if you're not struggling, you might be a sociopath with all that's going on in the world. So, okay, LaTanya, remind me the.
So I was wondering how,
Michelle.
Michelle. I was wondering how, you know, the awareness and competency plays.
Oh, that's right. Under the jurat and the swearing. You know, I think I would say the same thing in that. So Michael Clausen, he likes to say that he thinks one of the reasons that we should ask, that we're supposed to ask that, is really to kind of snap the person out of whatever reverie they're in and have them go, oh, what am I doing? I'm swearing to the truth of this. Give me a second. Let me read this, because I don't even know. And you've seen that, right? You've seen the person like, oh, hold on a second. What is this? And so I think, I don't know that I agree that's why that requirement is there, but I think that that is, it's letting the person know that they're on the hook for whatever they just signed. And so I would say that our role there is, by using those words, is to let them know you're about to be on the hook for whatever happens, whatever you're signing here, and you're swearing this under oath. And so, and I'll sometimes say, I'll throw in perjury and things, something like, not to scare somebody, to make it, you know, you're under oath, so there could be perjury involved. Let's just make sure you're good with, you don't want to do scare tactics, because then the person will be like, oh, you know, I'm scaring me, I'm bailing out. But I get a sense that, I think that, that if I got the sense that the person understood, yeah, I'm agreeing that what I signed is what I believe. I don't know that that's, my analysis would be that much different. I think you're right to go there, because now we're kind of assigning something as a physical thing for the most part, but having them swear to something is asking them to mentally acknowledge or think about that, right? So we could, in theory, say maybe we should scrutinize that a little bit more. I don't know. I think if they raise their hand and they say the words and it doesn't seem like they're just parroting it back, then I would probably go forward on that too. If it seems like they're just mimicking you, because sometimes you'll get that. You'll get people who just repeat. And in some cases, if I'm not sure, if someone's tracking and I ask them and they say yes, I'll ask them the reverse of that question to see if they say no. Am I making sense? So, because sometimes people will just say yes, yes. You seem like a nice person. Yes, yes. And so if you then reverse the question to make sure then that they're not just saying yes, a little bit of that I think is okay. And I don't think that's psychiatry. I think that's just logic. You know, I just want to make sure you're not just telling me what I want to hear, because I don't want to hear anything other than this is what you want. I'm here for you. If you don't want to do this, then I'm out. I don't want to be here. So I don't think that I would add any extra. I would look closely to make sure it seemed like they were tracking. And I would just say, you understand that the purpose of this. Do you have any questions? The reason we're doing this is because they want you to be under oath for this. And there could be, if this is not information that's true and correct, there could be some implications down the line, and we wouldn't want that. And then if they respond in a way that seems like they understand it, then I think I'd be okay. I think I'd just go forward.
Because I do ask them, did they review the document? Because when I do get there, when I do ask them, did they review the document? They were like, no.
Because nobody
don't
does.
know what is in it.
I mean, let's be real. Nobody does, right? I mean, and I don't mean nobody, but I mean close to nobody. Most people are like, I want to do a thing. Somebody told me I got to sign this form to do the thing. I want to sign this form. Apparently I need you to help me sign it. And then hopefully I get the thing. Did you read it? Nah. You know, I mean, that's just human nature. And so is that unfortunate? Sure. But some of this stuff is pretty complex. I mean, you guys will sometimes read a little bit of a document out of curiosity. And I'm sure, I mean, I get overwhelmed. I'm an attorney and I read stuff. I'm like, whoa, what is this about? I don't even understand it. So I think we want to be careful not to be too, judgy is not the right word, but I think we want to keep one foot on the ground and just be real. The reality is a lot of our clients don't read the document. And in fairness, if they read it, and once they start reading it, they're going to say, Latanya, I got some questions for you. And you're going to say, I don't want you to ask me those questions. I don't want to answer those questions, right? So putting them on the spot like that, I don't, for me, I just say, and now they're requiring me to ask you to swear that this information is true and correct, the information in the document. And if you want to take another look at it, great. Sometimes I'll say, if you want to take another look at it, wink, wink. Of course you looked at it once, but I'm not saying that. I'm saying, you want to take another look at it? And if they care, they'll look at it. And if not, they're like, man, just let me sign. And that's someone with no competency or capacity issues. Let me sign it. Tanya, you seem like a nice person, but the sooner you get out of here, the sooner I can turn this thing in and get the thing, whatever the thing is. So I think that there's nothing wrong with having a thoughtfulness around that, but I would say don't go too deep, because we're not required to. We're not skilled enough to understand what that means. If we ask them to wade off into the forest, we better decide what we're going to do with that information. If that information that comes back is messy, and a lot of times it's going to be messy. So for me, I need to see your ID. What am I here for to help you with today? Tell me a little bit about what you would like for me to do here. How can I help you? I mean, that's just customer service, right? You go to Starbucks, you go, how can I help you today? What can I do for you? That's a perfectly legitimate, polite question. That person should probably be able to answer it. And if it doesn't, if what they say makes no sense, then that's red flag number one. And if, oh, Mike, I just need you I'm getting something notarized, and this is a deed, and I need to sign this. And okay, great. All right, good. Okay, if you have any concerns at any point, you let me know. And if they're vibing with you, I would go forward. Now, I need you. Now, a requirement of this one is I'm going to need you at the end to swear that this information is accurate. Are you comfortable with that? Are you comfortable with swearing that it's accurate? Because we need to do that. But if you're not comfortable, well, then we're not going to go forward with it. I think a lot of this can be framed in terms of making your client feel comfortable. And in that process, you will be getting feedback as to whether that person doesn't really want to go forward. The only one that I had that was really dramatic is I had and it wasn't even about capacity or competency. I showed up. This was an older woman who spoke only Spanish, and her son was there, and this was a loan signing, and she was crying and speaking Spanish, and I can speak Spanish, but I didn't let on. And he's yelling at his mom, sign it, just sign it, sign it. And she's crying. Oh, what is this? And I was like, I'm out. I am out. I mean, it was very clear that this guy was making her something. I mean, she's literally crying and you know, what am I doing? And so when there's something that objective, I would not suggest that we go forward. If a jury of 12 people is going to be like, oh boy, Latanya, whew, good thing you walked away. But then also document. And I did. I said, I walked away. The woman was in Spanish saying, I don't want to sign this. Her son was making her, she was crying. And then you walk away. If a jury of 12, if a reasonable group of people is going to look at why you walked away and say, good job, then that is all that matters at the end of the day. And I think that for the most part, if you can put objective reasons, if your gut is telling you something's wrong, that's not good enough. If your spidey sense is telling you something wrong, that's not good enough. You need to be able to say clearly in writing for a jury of 12 that will never be there, that will never arrive. But if they ever do, what do you want them to see? And then on that day, when they say, why didn't you assess this person's capacity? Well, I'm not qualified to do that. But look at my notes. If you're concerned about it, you take a look and then fight it out in court if you want to later on.
I think the oath part is just more so of they're shocked that I'm having to put them under oath because a lot of notaries don't.
Yeah, well, that's a separate issue. Is a lot of notaries don't do it, and because they feel uncomfortable, and so they just don't do it. And but that's a separate issue. Yeah. I think the real reason is because they don't want the signer to later on be able to say, I didn't know what that was, right? You know, it's basically like, dude, you're locked in under oath. This is gonna be really hard for you to get out from under if you're lying to me. And so that's really what that is. It's an attempt to lock it down and say, we're not going to court on it. You signed it. You were under oath, and no, you're responsible, pal. I think that's what it's really designed to do. But you're right, because a lot of notaries don't do it. But that's a separate issue. That doesn't have anything to do with capacity or competency. That's a notary who feels like that's weird. I don't want to do it. I'll skip it. Who's going to know? You know. Tammy, you're back.
Yeah.
Can you hear us, Tammy?
I am back. Thank you.
I feel like it's like a seance. Tammy, can you hear us? Are you with us? Are you in the room?
Yes, I am. I'm so sorry. My computer was the battery was low and I had it plugged in, and for whatever reason it wasn't charging and it died.
I would say to your scenario, I would say don't beat yourself up about that one. I would say domineering spouse, that's whatever. That's a thing that doesn't have any bearing on it. Not knowing the date, to me, I don't have any concerns about that. To the extent that the person seems to like not really know what am I signing and why, that part would start to make me a little bit nervous. And know that even if you made a mistake there, and even if you shouldn't have gone forward, there are plenty of mechanisms by which that can be challenged later on. And so you are not fully on the hook for that. There are lawsuits and other processes and things that people can initiate. So I want to say is, because it can be lonely as the notary. You show up, you're the only one there. You feel like the weight of everything that's going to happen for the rest of this person's life is on you. And it's not. That's not ever a burden that we're supposed to bear. Did you ask for their ID? Did you get them to sign the document? Did you get them to sign the journal if that's the requirement in your state? Did you get a thumbprint if that's a requirement? If you did all that stuff, that's your responsibility. And there was nothing glaring. I'm not hearing this person is like swinging from the ceiling and you know speaking in tongues and doing all kinds of things like that. So I think absent something super dramatic, you're probably going to be fine. So it's good. It's good for us to think about these things, but I think we don't want to overthink about them. because then we're doing our clients an injustice. We're there to perform a service. And if we walk away, then that's an imposition. Because I'm guessing we probably would want to get paid for our time. And now that person's, maybe you walk away and you don't charge. But if you do, which is fair, then they got to call somebody else got to come. I mean, that's putting a burden on. And time could be of the essence in the scenario that James gave us. It's entirely possible that if James walked away, this guy could die before he was able to do what he needed to do next. That's a little dramatic, but maybe not. So on the day that I end up, and I think too, having been hospitalized before, because I run myself ragged, suddenly a lot of big life stuff comes into focus. When did I fill out my advance directive? When I was in the hospital, because I was like, oh boy, I better be, sometimes you make a lot of big life decisions because you ended up in the hospital, and now like your mortality is in your face. So I guess what I'm saying is there are so many reasons why someone might appear to be stressed out and acting a little strangely, or maybe not at their best. Medical reasons, to quote James, why someone's maybe skin complexion might appear a certain way. But if that person's telling you, yeah, hey, hi notary, hi Mr. Notary, can you help me out? I think we do it. I think we go ahead and do it. Other questions?
Anyone have any other questions they want to propose to Mike? I do want to play devil's advocate for one
please.
minute.
Please. And then I'll read a couple of these from a couple states real quick that do speak a little bit.
So, we talk about the oath and we talk about the person saying, yes, I swear affirm the information is proven correct. It's really about their truth sometimes, right? And not necessarily our truth. So I once had an individual come into my office and he had this 50-page document that he had written, and he wanted to tell me what it was about, and he didn't want to pay taxes, and it was addressed to the president and the IRS. And he talked about how he was not of this earth. His mother was an alien. She dropped him here. He's a sovereign being, so he should pay taxes. But on and on. And of course, he attached at the end of it like this sort of version of an oath or affirmation, but not really compliant in New York State. And so I had to say to him, here are your two options, right? I have to do this and I have to do that. And he said to me, well, no, I wrote it this way. You have to notarize it that way. I can't notarize it that way in New York State. Mm-hmm. But as we were talking about this to an attorney friend of mine, he said, well, you dodged a bullet because you would have tell him no. And I said, well, that was his truth, right? And if he's telling me that information is true and correct, unless I have, and we would think that probably wasn't the case, but who knows, right? Maybe tomorrow we'll find out that there are aliens if he was dropped here.
Yeah.
That's one of those things where it gets complicated, right? Because it then becomes subjective, right? Not objective when it comes to those types of situations. Would you agree with that? Or do you feel like, nope, it's 100% wrong and you just not going to do it and walk away? Like it's a tough place to be, right?
Yeah. I mean, again, I'll parse that out into a couple pieces. One, if there's a form we got to use it, capacity or no. And to me, that's just a difficult customer who wants to do it their way. And I'll say, sir, I want to help you out, but I got rules. And so if we got to use this form, we got to use this form. And if you're not interested, I completely respect that, but I got to pack up and I got to go. And you can, best of luck to you with the next notary, I think is how I'd handle that. If he believes in space aliens and these other things, you're right. Who knows? I mean, hey, I'm a big Star Trek fan. I'm hoping there's a bunch of aliens out there. And with the sheer number of planets and galaxies and universes, billions upon billions, there's got to be, I think. But I think that having beliefs that seem a little out there, I mean, I feel like in the last few years, we're hearing otherwise reasonable people have some pretty wild beliefs about reptilian legislators, I mean, just really weird stuff. So I think and those are people that are conducting their lives otherwise normally going to work and paying their bills or whatever. So I think that even if there was some, for lack of a better phrase, delusional content, if the person seems like they're generally making sense and they're like, hey, this is my house, I'm selling it, or this is my car, I'm buying it, or whatever, I would probably proceed based on that too. People say a lot of weird stuff these days and seem to somehow be functioning in society. So I think that we wouldn't want to be the judge of where that threshold is crossed. If they are holding, some piece of paper written in crayons and saying that the aliens, are giving them permission to do whatever, then on that, I think I would probably back away. But if they've got a form that seems otherwise appropriate and they're willing to show you their ID and this and that, and I wouldn't document too heavily about the space aliens because I think I would, maybe be working against my own interest if there was a challenge to that. But I might say something like, individual did seem to go on a bit of a tangent about aliens, but otherwise seemed aware of the transaction. I mean, I think you can acknowledge that someone is a little unique without having to throw the baby out with the bathwater and say, but otherwise we had a good conversation and the person seemed to be aware. I would use the word aware. I wouldn't use capacity. I wouldn't use competence. I would say the person seemed aware of the proceeding. And I wouldn't write that every time. I would just do that when the transaction felt really weird, or if my gut was feeling some kind of way, but it wasn't enough for me to objectively document why I'm not going to notarize. If I go ahead and notarize anyway, I think I would say, there was some indicators of something, but otherwise it seemed okay to proceed. And that way, that's good information for if there is a legal challenge later on. Maybe it's right for that transaction to be challenged, and maybe it's helpful for them to see, even the notary had some concerns. They didn't have enough concern to not go forward, but they raised some concerns. Maybe we are sending a message into the future that would be helpful to that client if for some reason it was determined by the professionals after the fact that they really were not, they should not have signed that document. And then we're just sending that message.
Objectivity is important here, right? When it comes to things issuing oaths, yes, we want to be helpful in things. There also has to be a little bit of that, hey, I'm not judge and jury here, right? Like they're still, if they seem aware and they really believe what's in that document, whether I believe it or not, right? Unless it's so bizarre, that's on them, right? And I just want to make sure that we know as we talk about these kinds of things, that's an important piece of this puzzle too, right? We want to make sure that we're not denying someone the right to have something notarized because their belief system. And I say that generally because I even, just not out there sorts of beliefs. We're so divided in society today that it's so important to make sure that regardless of someone else's belief, right, we're not judging them based on our perceptions, right, or what we feel like is our reality.
Yeah, and I think that for your thought exercise, and Michelle, I see your hand up. I think for your thought exercise, that's a good one. I would say that if someone has an example of something like that actually happening, then that would probably, because I would imagine most people on this call are going to say, nobody's ever come up to me with a really bizarro fact pattern and wanted to swear off on it. But as a thought exercise, I agree with you. I think that's the point. I think if somebody showed up with like loan docs and they had filled in the blanks with like, lizard aliens are taking over the government or something and written that all over it, then you might want to be like, this is not what's supposed to go on this form,
and certainly that would be the receiving party who's going to be like, hey, I can't take these.
Yeah.
So that decision actually is taken, that decision is almost taken away from you because your competition then becomes, hey, the lender's not going to take these documents.
Right.
Like we just can't do that, right? Then it's no longer about you being the notary. It's about the person receiving those documents, what happens.
But I think to clean up, or for me in my mind, to clean up your devil's advocate scenario, if someone just brought in a story about how the aliens are in my house or whatever, and I just want it notarized for my sake, it's not going anywhere necessarily, then I would be like, sure, of course, I'll notarize that. But if it's a formal form that is required to, get benefits from, I don't know, the IRS or whatever, and you've scrawled in crayon and strange, symbols and things on that, I would probably say, this is not, I think, what they're expecting to receive. And you might want to show that to somebody before you have that notarized by me.
Michelle, how are you? Jump on in here.
I'm good. I'm so glad you opened this up to non-New Yorkers.
Oh, of course.
Mike, I got to go back to the sovereign citizens.
Yeah.
They're hot and heavy here in Alabama. And so feel free to tell me I need to back it up, but I have stopped accepting notary appointments with them. When I did notarize for them, their documents, I found were gibberish. It was just gibberish. The notary certificate made no sense. The form, it was written in English, but for those who've not experienced this, the documents themselves go in some sort of circular language. And then I made the mistake of Googling sovereign citizens and came across a page that says they're considered domestic terrorists. So Am I discriminating against these folks? And what would you suggest?
So I will bite my tongue because this is a professional environment and this is a recorded presentation. But I think what I would say is everybody has a right to believe whatever they want to believe until believing a certain thing is causing harm to other individuals. So I don't care what people believe as long, I mean, that's not totally true. I do, but I don't get to care about it officially until someone's doing harm to somebody else. So if somebody wants to write a bunch of gibberish and we're going to attach to the extent that in California, we are able to attach a loose certificate that has the correct language on it. And if they're okay with me doing that, then I would go ahead and notarize. But I guess you could be, I hesitate to use the word discriminating, but I'll use the word generalizing in that maybe the 14th sovereign state person that calls you, that wasn't going to happen. Hey, we're going to have everything in order. And so I would say, are there certain questions that you can ask in advance just to say, now, when I come out, I'm going to, because or do you say, do you charge for your time regardless of whether you end up notarizing? Because if you're charging for your time, then when you get out there and it's gibberish, then you can say, I'm backing away, but you still owe me whatever. Now that's going to be an uncomfortable transaction maybe, and you might get some resistance. But I guess is there some other way to guarantee that it's not going to waste your time? If you can charge for the visit, whether you notarize or not, then I would suggest considering that. I would suggest asking a few questions in the front end, if you can, without getting too personal, to say, sure, and I'm going to need to put this in my journal. What kind of document is this? And if they say it's, and is there, does it have notarial language on it? Was it on the form? If not, I can provide my own form, but it's going to need to have the official language. I think there's ways to sort of ask those questions in advance to not waste your time. But I would say, yeah, if you're wiping out an entire class of people that you just won't go see, and I'm not saying you're not, it's not understandable why you wouldn't want to go out. But I would say that
Yeah.
that's stuff, because
Yeah.
somebody can believe, people believe some really interesting stuff these days. I have my undergraduate is in science, biology, and science seems to have left the building a little while back. So facts and things for some people are not really important anymore. It's all about what you feel and what you believe, whether you have any basis to believe in it or not, other than your heart tells you so. But I think if that person is still engaging in daily life and engaging in transactions, that person has a right to have something notarized as well. I wouldn't suggest you go too far, or you might, if you went out to one individual and you got burned, you might not go back out to that same individual again.
Mhm.
And again, if you can charge for your time and know you're going to get paid, then, you know, a lot of people say, I'll just charge them for my time, and then it doesn't matter if I can notarize or not. I don't know if
And I appreciate that, especially because I train notaries, and it did cross my mind that it's one thing for me to take certain steps as a commissioned notary, but it's something altogether different for me to put that off on students and all. So
yeah, I think if there was an area where I have been burned enough times, I might say I'm happy to come out. I'll be honest, I've had some, and I wouldn't even say it's about particular group. I would say I've had some interactions where people have some documents that don't really fit the standard format, and I just want to let you know that I have certain rules that I am restrained by. And as long as all the documents are in order and fit the requirements of the law, you got it. And if not, then we won't be able to do business. Oh, of course, everything's great and everything's in order. Okay, well, I'll let you know that I do charge for my time one way or the other, just in case it turns out that they aren't in order, or they don't follow the format. And that way you can kind of, I like to try to manage the person's expectations and have that conversation in advance. You know, if you, in a perfect world, sometimes I will say, because I notarize for a lot of people, I notarize for, I'll give an example. I notarize for some Holocaust survivors who are, there's not a whole bunch of Holocaust survivors left, and some of them tend to be very elderly, and frail, and I don't want them to have to come all the way to my office if I'm not going to be able to notarize. I don't want to have to turn somebody away and be the bummer in the room. So to the extent that you're able to, I will sometimes say, do you want to send me the document in advance if you can, or can you show me the document if you're comfortable with doing that? Can you show me the document in advance? Because sovereign state or whatever, people bring all kinds of weird stuff that they think needs to be notarized and maybe it doesn't. And sometimes there's ways for you to notarize it anyway because they want it notarized, even if it doesn't need to be. I just hate wasting people's time, honestly, and I hate wasting my own. But is there a way that I can see the document in advance, just so I know that I have the right paperwork to bring out and the right notarial forms if I need to add anything? Some people might not be comfortable with that. So I don't know that you can completely say no to the person who is not willing to do that. But if they're willing to show you the stuff in advance, I mean, they send you a bunch of, to use your words, gibberish. You can say, I can notarize that, but I'm going to need to add this form. And you can send them a blank form copy of, I'm going to need to add this. You comfortable with that? No, we're not doing that. Okay, well then, best of luck to you. That's a requirement of mine. I didn't make it up. That's what the law says. It doesn't matter if I like it or not. I just have to do that. And I don't want to waste your time, sir. So have a good day. And thank you. If you change your mind, call me back. That's how I would handle it.
Excellent. And some states do have directives, I don't know about Alabama, but as to when you can deny a notarization, right? So if you have any questions about that, I certainly would urge you to look at your state law. That might be a good way out sometimes for not notarizing in an uncomfortable situation.
And I wondered if I could just to read a couple of these real quick, just because I had referenced it. So somebody sat through the whole recording and said, the guy said he was going to talk and he didn't even talk about it. So just a couple of examples. These are just from slides, and this is from a few years ago, so this may have changed. But so Florida has or had some language that says in their statutes, in the Florida statutes, a notary public may not notarize a signature on a document if it appears that the person signer is mentally incapable of understanding the nature and effect of the document at the time of the notarization. So that does start to get pretty close to the stuff that I'm saying I wouldn't mess with. Understanding, what does that mean? That's very vague, but that is something where if that's what your state law says, then you probably should do a little bit more of those questions. And you probably should do it for everybody, every single time. Georgia's got some language, or had at the time of this PowerPoint. The notary is given the opportunity to decline to act if he has, quote, compelling doubts about whether the signer, quote, knows the consequences of the transaction requiring the notarial act. So that was interesting because compelling doubts to me sounds like red flags that have presented themselves to the notary, as opposed to the notary having to get a sense of whether they're understanding. The first one, the Florida one, sounds like maybe there's a little bit of responsibility on us to make sure they understand. Compelling doubts to me sounds like there was something going on. This is the Marcy scenario. There's alcohol everywhere. Person seems drunk and, marijuana in the air. That's compelling doubts. I don't know that I have to actively pursue any information, but if it's in front of me, I have to be aware of it. But this one actually kind of punts down the road of beyond the initial signing itself, but knows the consequences of the transaction requiring the notarial act. I would argue that absent an attorney being part of that conversation, that is beyond our ability. I mean, we're not just asking do you know what this document is, but all the consequences. I mean, there could be a million consequences from that. So that language makes me nervous. And I think you almost need an attorney in the room to talk about all the different consequences, but that's the language that is in the Georgia code section. And then just one more. And at the time, these were the only ones that really spoke to this at all. And this is a few years ago now. So I don't know if there's other states that have added language. So check what your local notary laws say in your state. But the Illinois example says a notary public shall not take the acknowledgement of or administer an oath to any person whom the notary actually knows to have been adjudged mentally ill by a court of competent jurisdiction and who has not been restored to mental health as a matter of record. So that goes back to one of my earlier scenarios. If that person has been placed on a conservatorship, if there is some legal action that has determined that this person is not able to sign things or enter into contracts, then that decision is taken off the table. But you wouldn't necessarily know that. And that's why I think the language is whom the notary actually knows to have been. So in that scenario, I would have to know that this person is on some sort of conservatorship, or that there's some court order that they don't have capacity. And then I went ahead and did it anyway. A lot of these things are in the medical chart, or maybe the hospital doesn't even know. I work in a lot of hospitals where they don't know that somebody is on a conservatorship. You have to make some phone calls to some different legal entities sometimes to get this information. So and to say that we'd have the burden of calling all over town before we notarized it for anybody that came in front of us to see if they were on a conservatorship or something of that nature, that's not realistic. So I think I like what Illinois says. If you know they're on a conservatorship or something, a court determination's been made, then back off. But I would imagine that we would have done that already. I mean, again, the kind of people that come to an organization like this and are about bettering themselves and raising the bar on themselves, if they know there's a court order, they're going to back away. So I think the Illinois language doesn't scare me. The Florida scares me a little, and the Georgia one scares me a lot, because knows the consequences of the transaction. I don't know what's going to happen to me tomorrow. Never mind whether I'm signing something or not. So that's and of course that I'm sure they don't want us to go that deep, but that's just some examples of the law where it does start to call that out. In most areas of the law, certainly California law, there's no language like that at all. So to the extent that we are assuming that duty, we have done it voluntarily, and there could actually be consequences for assuming a duty that doesn't exist.
Does anyone have any questions about any of those state laws or scenarios that they have or things that we haven't touched on? Mike got a lot of information out there, and I'm certainly grateful for all of this. Thank you so much. I'm happy to take some more questions. Lori.
Hey, I just want to thank you, Mike, for this. For those of you who don't know me, I'm the notary administrator in Montana. And we do have language in our law that talks now very specifically that a notary, when taking an acknowledgement, witnessing a signature, performing a jurat, must determine that the principal is signing the document knowingly and willingly for the purposes intended.
Yeah.
And part of this came about in trying to keep things pretty much even between the remote signings and what the ULC laws were talking about in terms of determining, you know, that the signer knows what they're doing on the audio visual recording and that sort of stuff, and not making a big difference between the in-person and the online transaction. And so, you know, what I've been teaching in my classes and putting in the handbook and so forth is that this is a really very basic reasonable care standard, and basically saying, okay, when a customer asks you to notarize something, if you're filling out your journal and it asks what type of document, and they can tell you what type of document so that you could write it in your journal, and then you look at the document and it pretty much looks like that's what it, you know, matches up. You have met that threshold of they are knowingly presenting the document, and, you know, just asking, and you're willing to sign this knowing what you know about it, and they say yes, you know, you have met the standard required by Montana law. And so far that's worked really well, until a couple of days ago I received a complaint from family of a person who was in a nursing home, and the family of course is alleging that the, you know, elderly family member was not competent to sign this document and blah blah blah. And of course now the notary is saying, well, yes, they did, they met that, you know, God love her, she had been to one of my classes and she was, you know, saying, this is what I asked, this is what I did. And, you know, I just really appreciate you kind of underscoring the fact that we're at least not requiring the notaries to go into any kind of extraordinary medical or psychological or any in-depth inquiry as to the document, but enough so that there's, you know, more than a, hey, this is the power of attorney, you're okay signing it? And they say yes. That to me isn't enough, but if they can tell you this is power of attorney, I need to have it notarized, and they answer yes if you say, and you're willingly signing this, I think we've met the threshold.
Yeah, and thank you for saying that, Lori. I appreciate that, and thank you for being here, by the way, and for all the work that you do.
I appreciate it.
And I think that certainly in a place where it's called out in the law, then yeah, then we need to pay a little closer attention than in, say, for example, in California, where we don't. And I'm
Yeah.
super all about following what the law says, but I don't want to assume a burden that doesn't exist, because I shouldn't.
Sure.
And I understand this knowingly and willingly. I understand why legislators would want to do that. And I understand why they're worried about but they're really placing an unfair burden on the notary if they expect anything more than what you just described. I think you're right in that we need to keep our analysis very simple. We need to not expect, because that's a lot of pressure. Knowingly, I mean, what is that? How deep is that knowledge, and how deep is is there a quiz? And I do like that. I wouldn't use, as I think I've said this earlier in the presentation, I wouldn't use leading questions. This is a power of attorney. Do you want to sign it? I would say, what am I here to do for you today? And then they would presumably say, oh, this is a power of attorney. I'm hoping you can sign it. Leading questions are always dangerous. And
I agree. That's why
leading questions. And that's why
yes,
they're frowned upon.
that's why I suggest that they start out by, get your journal out there, and then before you've done anything else, you start pulling out and you say, and what kind of document is it? So that you're filling out your journal as a notary, they have to tell you something that's going to fit in that line. They have to be, and I also use it quite often in my classes to explain, this isn't just about the elderly or the infirm or whatever, as you mentioned earlier, but notaries are often asked to notarize documents that are written in foreign language that they do not read or understand.
Exactly. Right.
And the same rules apply. It's not whether you, the notary, know what it is. It's whether the principal knows. And if they tell you it's a power of attorney and this is what they want to sign, you're good. You're covered. You've gotten the word from them that they know.
And
I really appreciate you kind of backing me up on this.
No, I think I might even modify your question a little bit to say, and I'm just thinking out as we go here, to say what I need to put in my journal, what is this form called, or what is this for? What is it that you're trying to do? Because I have notarized for people who are, I'm sure of their competency, or at least I think I am, and they have to look at the form. And a lot of these forms are called such stilted language that you even read the title on the form and it's so obnoxious, it's not even indicative of what. So I just notarized for one of my coworkers, I think yesterday. And I said, what is this for? And she said, oh, my kid, my ex-husband is taking my kid out of the country. And that to me is almost more powerful than someone picking up a piece of paper and saying, state form for foreign passport travel, because then they're reading. Now I know they can read, but I don't necessarily know that they understand what that is. So for me, it's almost more powerful for them to tell me, what is this for? What are you trying to, what is this for? Or you can ask both. What is this document I need to, or what is it for? What is it that you're trying to do? Or what is it you're hoping to achieve? I'm not trying to get in your business. I just need to document this. And to the extent that they can answer the, what is it for? That is more valuable to me than, do you know what the name of the form is? Because anybody can read it, right?
Well, and generally it's been my experience actually doing this. When you ask an open-ended question like that, you tend to get the whole story thrown out at you.
That's right.
They don't stop with the name of the form. They tell you why they're doing it, who's involved,
You're right.
what time the plane leaves and everything else.
Yeah, sometimes they get so chatty, you have to try to get them to stop talking.
It's like, no, I've only got one line here. What do you want me to put here?
But what I like about that is it's naturalistic, it's organic, that the person is giving you all this information and you aren't having to poke and prod and get in their business and condescend or be nosy or judgy. I think, you make a really good point. I think in my line of work, the more I am talking to someone else like they're a human being, which is what you're supposed to do, the more that person is going to respond in a very natural way. And there's some authority that we have, or they were perceived to have in these transactions. We're the one with the stamp and the official forms, that I think that there is a willingness to open up. As long as we are kind and polite and professional, I think we can ask those questions. And I'll sometimes say, when I'm representing clients in other areas of my work, I'll say, I'm not trying to be nosy. I just have to ask a couple questions so I can best get for you what it is that you want. And so to the extent that we can say, especially in a state where it's required. I'm not being nosy in Montana, right? I'm not being nosy. I'm required. I'm required to make sure. You can call it out. You can say, I'm required to make sure that you're knowingly and willingly. It's required of me. So I need to ask, is it you want to do this, right? I mean, it may feel a little awkward that I'm asking you this, but it's actually in the law. That's why I'm asking.
Yeah, good point.
As long as you can push away from, I'm just some nosy person, you can
Well,
say,
and I
that.
think using the journal as
I
a
think that's right.
prop,
But
if you will,
also-
that also helps because they see that you're taking that information.
That's right. That's right.
You know,
but I wouldn't be afraid in a case where it's in the
good
state
point.
law to reference it. The law requires me, to make sure that you're entering this knowingly and willingly. And of course, we wouldn't want you to, and I wouldn't want you to enter it if you weren't. Do you have any thoughts about that, or you want to say anything about that? Anything that would help me to understand? I think you could go that far. I think you wouldn't make them suddenly plead their case to you, and then then you decide yes or no based on that. But I think you could almost engage in the conversation and call out the language in the statute. Or if for any reason, maybe you don't bring it out until somebody does something that makes you think that knowing or willingness might be an issue, and you could say, I'll be honest, I heard you say something and it made me think that I should probably ask. I'm required to make sure that you're knowingly and willingly signing this. And you said something that maybe I misheard you, but it made me think that maybe I should make that clear. Do you want to tell me a little bit about this, just so I understand? If they really want you to sign it, and frankly, the more they're wanting it, the more they're going to fight for it, right? Because they're going to want you to understand. So they will explain themselves because they're like, hey, I need this notarized. What do you need to hear from me? I'll tell you. So even if they don't want to tell you their life story, they will want to make their case to get what they want. And if the family members or everybody else is jumping in and making their case, then okay, I need to make sure, I need to hear from this person. And I don't want to be rude, but I'm gonna have to ask you to leave the room if you're not going to give me enough space to hear from this person. And if you're not going to do that, then I'm gonna have to pack up and leave. So I think you control the environment in a way that is respectful, but you are not there making up the rules for the notary. Those rules are set for you and you have to follow them. And I think it's fair to call it out.
Thanks, Mike. I appreciate that. And this has been really great. Thank you, Marcy, for hosting this.
Oh my gosh, I'm so glad that you were able to come, Lori. Thank you.
And
I love it when people who are on the East Coast understand those of us on the West Coast have to work around the time zone here, but it worked out very well for me. Thank you.
And I just want to add to what I just said about Lori and Montana. The opposite of that, if your state law does not say anything about it, then I would not do those things that I just said. I wouldn't say I'm required to knowingly and willingly, all that stuff. I would say, if it's in the law, then use it to your advantage. And if it's not, still do some of the things we talked about today, but I wouldn't go so far as saying it's a requirement, because it isn't. So in some areas where that's in the law, maybe that's a helpful tool. Maybe that'll make you feel more comfortable being more vigilant in that area, because the law says you have to. You're not being nosy. It's the law. It's your job. Just be careful about importing that too strongly when it's not in the law.
Any other questions or concerns? Or Krista, jump right in.
Hi there. First, I want to say I'm great. It's good to see you. I'm sorry I don't have my camera on. And first of all, I just want to say thank you, because this is like a huge red flag for me, because everybody and their mother in my area sends everybody who might have dementia or other issues to my to my phone. And so it gets to be a little hairy and scary, because yes, I am a paralegal, but I'm outside of the law office. I'm just a notary signing agent, or people call me just to notarize. So it's a complete different capacity. So people like the local nursing rehab centers and stuff, and then once people get to a certain point or they don't have family members, half of them are getting admitted without power of attorneys, without healthcare proxies. And then I get there and I do all this stuff and I ask all these things and they assure me everything's fine. Then I get there and I find out they have a diagnosis of dementia. Now in New York state law, there's nothing that says you can't notarize somebody because they have dementia.
Right.
But sometimes I feel very intimidated Because once I hear that, I can't really deny on the fact that they have dementia, but it certainly makes me nervous. And when you do hear those things, are there specific questions right off the bat that you could say or ask once you find that out?
I don't think so. I think it's right for you to feel, I don't know if I'm using your words, nervous. I think it's right to feel some hesitation.
Right.
And I think my next step is let me go talk to the person, because when I meet with a client, and this is in one of my other many gigs, and I've got all this documentation that says the client this and the client that, I read all of it and I think maybe, and now I'm going to go talk to the person and I want to get their side of the story and understand what their position is. And I think you take all those things in and all that information, you put it into the soup or the stew, if you will, and then you go meet with the individual and you have an interaction with them. And if the totality of the circumstances, if you will, points to, I am not feeling comfortable with this, then I think you document that, this individual is indicated to have Alzheimer's. That's not a reason to deny. However, subsequently in my conversation with the individual, it appeared to me that they were not making sense. That in combination with the above, you don't have to get that.
Yeah, like some confusion. I try to, ask them about, what document we're signing, how are you feeling today? I always try to find out what their mood is too, because I do understand that, at one given time, that can change. And so my assessment is, I guess a lot of times, as soon as that happens, people are like, oh my God, I got to do this. Like you said, mortality was up in your face. And so families are panicking, and then you're sitting there and like the whole family's in there, like 8 people, you're like, I don't want to sit there and have to be the bearer of bad news, and I've had to do that. But what I've done is I've actually asked a family or a couple of family members to go outside of the room so I could speak to them for a minute.
I think
when that's happened,
Yeah, I think that's right. I think that to that I would say yes. I think we've all been, or we could all be in that situation where you don't want to be the bearer of bad news. I've had a Holocaust survivor come in to meet with me, and I've had to tell him I can't notarize this. And oh my gosh, like I'm dying inside, right? But to me, and not because they're a Holocaust survivor, but because the documentation wasn't appropriate, or there was something that legally I couldn't do. And so I think that all of that goes into, you got your scale that says do it, and you got your scale that says don't. And I think each piece of information goes on the scale, and then when it's showtime, it's just which way is it tipping. And having to bum everybody out, that's a human thing that hurts, but I'm sorry, too bad. I can't be pressured by that. And but if I can factor that out, and we're human, so we can't completely factor that out, but to the extent that I'm having a conversation, she's making a lot of sense, he's making a lot of sense, they're making a lot of sense. I don't want to attach pronouns to people in the fact pattern. If you didn't, I can't remember if you did. And if that person is making sense to me and we're having a conversation, I mean, Alzheimer's is on a spectrum.
Right.
People with like a little bit, people with a lot, people that in this time of day, they got some, and then it's fine. So, I mean, and diagnoses carry so much stigma too. You can attach a diagnosis to someone and it can color everything that happens to them for the rest of their life. And in many cases, it's not even right. And so these black and white diagnoses, Alzheimer's, for example, that might be early, that might be not advanced, that might be something that we're focused on, but it hasn't really risen to the level where they're not in a position, and we're not qualified to make that determination. So if they're making sense to me at the time and we're having a good conversation, who am I? I'm just a simple notary. I'm just here to notarize a signature.
Right. Yeah.
I would document that there was some indication about a diagnosis. However, our conversation was great. They indicated without prompting or without me leading that this is what they wanted me to do. And then I would go forward. Now, some people make their whole livelihood around skilled nursing facilities and these things. And so I think that's the thing where you want to,
yeah, so that's what they do. They're like, oh, well, she knows, we'll just send her to her. And then I don't always know, because I never know what I'm walking into. You know what I mean? And I hate having to be the doctor too. You know what I mean? When I'm walking in there and I'm telling social work, why do you call me? They're stage 3. Why are you calling me?
Right.
You need to tell them to go to an attorney.
And I think we need to acknowledge that that's a very heavy load that's being placed on you. And then also acknowledge that that is not a fair load to be placed on you, because that's not our responsibility.
Well, exactly.
Heavy things are happening to people in the world. And we can feel a certain way about that and be sympathetic and feel emotional pressure. But that, hey man, we didn't sign up for that. So if you send me into a mission that is so mentally heavy for me that I am not comfortable going forward, then I'm sorry, I'm going to have to back out. I just want to be careful not to set that threshold too low, so I'm not turning around every single time. Whereas I hear skilled nursing facility and I say, nope, then that your threshold's too low.
Right.
I think you go in and okay, a couple things on the go forward side of the scale, a couple things on the don't go forward kind of a scale, things I can put in my journal, and then a reasonable jury of 12 would say, you know what, Mike, I think you made the right decision. And then I think you just go forward or you don't. And I think, what makes me sad, and this is only going to add to the burden and the weight that is not your problem or our problem, is our society set up in a way where people who are in various states of distress, mental, physical, or whatever, don't always have an easy way to reach out and put their affairs in order in the way in which they want to. And if the notary turns around and walks away, it's not so easy to just get yourself in front of a judge or something like that. But that's not our problem. We can't let that pressure make us feel compelled to go forward or compelled not to go forward. I think for me, it's just, I'm interacting with a human being in front of me, and they make sense to me. This feels okay to me. If this interaction was happening in any other environment, I would be fine with it.
Mm-hmm.
If this conversation was happening out at Denny's or Starbucks or whatever, and I would have gone forward, I think I'm going to go forward here.
Right. Well, see, I really don't care about what facility, where, or when. It really shouldn't be the full determination of competency. You know what I mean? But
Yeah.
I guess, was it somebody else that was talking about, the facilities are like you said, they're like zeroing on, or they're saying, oh, that person can't do this and know that. And I've gone into rooms many times and people have, and I'm having that interaction and they seem fine to me.
Yeah.
What I've been trying to do was like screen people, because half the time it's the families that are calling and setting up the appointment for them. Right. And they don't always have all the information. So I try to talk to the family members as much as possible. And when I hear, well, they're starting to whatever. So I talk to them about, well, what are your interactions are like with them? Does she understand? Does she change her mind constantly? So I'm asking a lot of questions so I don't have to burden the individual I'm actually signing documents with a barrage of questions to help me. So I try to get a better idea of the competency, I guess, ahead of time. I've learned to do that now rather than feeling on the spot or bombarded.
I think that's fair, but keep in mind that family member's biased one way or the other. They're either wanting to answer those questions in a way that'll get you to go ahead and notarize, or
that too.
Or they're wanting to answer them in a way where you hopefully won't. And so they're not neutral for the most part. As humans, we always have some level of bias. And so I think you can ask those questions, but I think for me, it's, let me talk to the person. I want to talk to the person. And that my gut's going to tell me, I think, during that conversation, whether I feel comfortable going forward.
Mm-hmm. Well, thank you very much. I'm really appreciative of all your time tonight. This is great. Yeah. Absolutely great. Thank you, Marcy.
Oh, of course. Any other questions for Mike before we wrap up? It's your last chance.
Let me answer to one other piece to Krista's question, is that when they say, oh yeah, that person can't sign, I would say, oh great, would you mind just showing me the conservatorship paperwork or the court document? And if they go, what? No, we don't have any of that. Oh, okay. Because that definitely answers the question for me. Absent that, I don't have a definite answer. Can I go ahead and talk to her? I'd like to go talk to her. So I think if they've got that piece of paper, show it to me. And if they don't, then I appreciate your concern. I'm glad that you're concerned. It is a noble concern. But I'm gonna go talk to her because I gotta go talk to her and see how that conversation goes. Your concern is noted, but it's not necessarily the end of the story. That's how I would handle that.
I just want to thank you, Mike, so much. This was a great conversation. I know it went a little longer than I had told you, but you're the best ever. Really good information. I think that you did a fantastic job, and I'm really grateful you took time out of your busy schedule, because I know how busy you are to do this for us. And I'm grateful for all of you who came today and had great questions. I hope that this proved valuable. It gives you a little food for thought, and that if a situation comes up down the road, you can reference this conversation and maybe make a good decision at that time that you may not have made before, or maybe always has, and just reinforce that information. So Thank you all for coming. I hope you all have a great night. If you want to see more of Mike, he will be presenting at the NNA conference this year. So if you haven't got your ticket to Arizona, now is a good time. I don't know what he's talking about. What are you talking about in Arizona? I don't even know what you're
I've had a scenario presented and it's pretty wild. I'm just gonna leave it at that.
Oh, it's a secret. Okay, well,
Well, you and I can talk later and then
it's bound to be a great conversation and a good presentation. So if you can make it out there, we'd love to see you.
And thank
Thank
you
you
all
all
for
so
what you
much.
do. And thank you for caring enough to constantly professionally improve yourself and be part of organizations like this. I think the best of us are ones that know that we don't know how to do everything and we want to constantly improve. So thank you for being here tonight. And thank you for helping make me think about a lot of things as well. Thank you.
Thank you guys all so much. Have a great night. Take care. Be safe out there. Happy notarizing.
Bye.
Bye.